Good morning, this is your Kelso Report for Monday, October 8th, and I'm your host, Clark Kelso. Our cases this Monday morning include the definition of constructive possession for purposes of a sentence enhancement, what it means to distribute child pornography from a personal computer, and whether Proposition 218's voter approval for taxes applies to a so-called island annexation of one community to another. We begin with the sentencing guidelines in the Ninth Circuit. Under the federal sentencing guidelines, a conviction for unlawful possession of a firearm may be enhanced at sentencing if the government can establish by a preponderance of the evidence constructive possession of additional firearms. In United States v. Nungaray, the defendant pled guilty to one count of possession of a firearm that the defendant physically had in his possession during a gun sale to an undercover officer. The district court enhanced the sentence by finding that the defendant had constructive possession of the 4 firearms that he had sold to the undercover agent. On appeal to the Ninth Circuit, the defendant argued that he was just an intermediary and broker for the sale, that the guns were not his, and that he never had physical possession of the guns. Well, the Ninth Circuit rejected these arguments as being too clever by half. According to the panel, it strains common sense to say that while the defendant orchestrated the details of the gun sale, negotiating the number of guns and the consideration to be paid for them, he directed where the guns were to be delivered, he directed that the guns be placed in the trunk of the buyer's car, he permitted the buyer to look at them, and when he was satisfied, collected the money that had been negotiated and agreed upon as consideration for the guns. Strange common sense to say that with all that, he never had possession of the guns. The evidence, in fact, showed that the defendant indirectly controlled the delivery and placement of the guns in the hands of the buyer, and for the Ninth Circuit, that was enough to establish constructive possession. Next, we turn to the definition of the word distribution. The penalties for possession with intent to distribute or for distribution are usually more severe than for mere criminal possession. That makes it important to know how to prove distribution and to distinguish mere possession from possession and distribution. The object that was possessed in United States v. Budziak was several pictures of child pornography, and there was no question that the defendant had the pictures stored on his home computer. The issue was whether there was sufficient evidence of distribution to convict him on 2 counts of distributing child pornography. The evidence was that the defendant also had on his computer a file-sharing program known as LimeWire that allows users to search for and download files stored on other users' computers, so long as the files are located in a specially named shared folder and file sharing is turned on. Of course, as it happens, the default setting for LimeWire when you install it is to allow sharing. The FBI investigators found several child porn pictures in the shared folder, and the file sharing option was turned on. The FBI investigators had used their own peer-to-peer file sharing program to access the pictures on the defendant's computer. Well, this evidence was enough for the Ninth Circuit, which held that the evidence is sufficient to support a conviction for distribution of child pornography when the evidence shows that the defendant maintained child pornography in a shared folder, knew that doing so would allow others to download it, and another person actually downloaded it. You don't have to be involved in actively distributing it to others. Making it available for distribution through peer-to-peer programs qualifies as distribution once someone actually downloads it from your computer. Seems to me an interpretation that furthers the likely intention of Congress in enacting statutes prohibiting distribution. Finally, we have a tax case involving Proposition 218. Now, ever since the enactment of Proposition 13 in California, there really has been an ongoing struggle between local governments and districts and the proponents of Prop 13 over creative mechanisms for raising local revenues without requiring voter approval or two-thirds voter approval. As these creative mechanisms have been discovered, the proponents of Proposition 13 have generally introduced subsequent propositions to close the loopholes. The scope of one of those loophole closures was before the 4th District and Citizens Association of Sunset Beach versus Orange County LAFCO. The taxpayers living in Huntington Beach had been paying two taxes, which taxpayers in next-door Sunset Beach hadn't been paying. First, Huntington Beach taxpayers had been paying a utility tax of 5%. Second, they had been paying a retirement property tax of about $15 for each $100,000 of assessed valuation, on top of Proposition 13's 1% limit for Huntington Beach pension costs incurred prior to the passage of Prop 13. Well, until recently, the taxpayers of Sunset Beach have been spared those taxes. Now, Sunset Beach is a relatively small strip of land consisting of about 133 acres, which for over a century had been an unincorporated part of the county of Orange. But because of this small size, Huntington Beach was able, with the approval of the Orange County's Local Agency Formation Commission, its LAFCO, to annex Sunset Beach without a vote under California's Island Annexation Statute. So the obvious issue here was whether the residents of now annexed Sunset Beach could be subject to new local taxes that they had never approved. And this brings us to Proposition 218, which was enacted in the 1990s to stop local politicians from circumventing Proposition 13 by inventing new so-called assessment districts, which supposedly could impose taxes without any vote of the electorate at all. Well, given that history, the focus on creating new assessment districts, the 4th District easily concluded that Proposition 18 did not apply to the situation where one community was actually annexed to another without voter approval. Simply put, that was not the evil at which Proposition 218 was directed. And in any event, my guess is the residents at Sunset Beach can afford the slightly higher taxes to which they are now exposed. And that's it for today's Kelso Report. Have a great day in the law.